Court calls the case of the people versus Desir Exton.
Welcome in, because from this very moment, the tension in this courtroom is already thick. What looks like a routine docket call is about to spiral into a case packed with contradictions, second chances, and a judge who has clearly reached the limit of his patience. We're dealing with bond violations, drug testing failures, and a defendant who has already been given opportunities to stay out of custody, but now finds herself right back before the court. Here's what you need to understand. When someone is out on bond, the court is trusting them to follow strict conditions, especially drug testing and compliance with community supervision. Fail that, and the court starts questioning whether you deserve freedom while your case moves forward. And today, the judge is about to examine whether this defendant burned through one too many chances. Watch closely as the defense begins by admitting fault instead of making excuses, a strategic move to soften the court's stance. But then the conversation shifts into drug test manipulation, abnormal creatinine levels, and eventually a cocaine-positive result that changes everything. And here's the hook for all of you watching. When someone admits responsibility, does that deserve leniency? Or has the court already been patient enough? Stay with this case, because the judge's patience, the defendant's honesty, and the consequences of her choices are all about to collide. And the outcome could decide whether she walks free or goes back behind bars.
Do you have a client?
Yes, Your Honor. This is Matthew Mansour, Assistant Public Defender with and on behalf of Mr. Exton, who's approaching to my right. State your name for the record, please.
Deja.
All right.
Your Honor, there was a community corrections report dated April 9th. You have a copy of that.
I do. What were we? Really?
Your Honor, I'll address this right now. We have no excuses. We will not,
Mr. Allen?
and will never mislead this court. She takes full responsibility for her actions. She thanks this court for allowing her to remain out of custody and to continue to test. You have been fair with her. You've been sympathetic with her. She sincerely apologizes for her actions. I hope the court sees that there is something to be said about her appearance here today to take responsibility. And this is her first positive test since her very first test back in November.
Well, except for the fact that I have abnormal creatinine
I know,
throughout all of these tests.
yes, Your Honor, that is absolutely true.
Okay.
I don't know what the creatine is. I don't know what could cause
But
creatinine, whatever. I don't know what that is. But I do know what cocaine is, and that is,
okay, well, I don't know if you should say that out loud, but go for it.
I do know that she did test for cocaine on her last attempt on the 9th, and the last time she's
I
tested.
will usually see abnormal creatinine so that you know when somebody is masking a test. Not always the case. So you can place in perspective that I have mistest, abnormal creatinine.
This moment is critical because the judge is subtly signaling something important. He's seen this situation many times before. When creatinine levels show up abnormal, it can indicate dilution or attempts to mask drug use. Not always, but often enough that courts take it seriously. And notice how the judge balances skepticism with caution. He doesn't jump straight to punishment. Instead, he explains the pattern: missed tests, abnormal results, then finally a positive result once masking fails. In courtroom logic, patterns matter more than single incidents. This is also where credibility becomes everything. The defendant is trying to show accountability, but the court is comparing what she says now with what was reported earlier. Judges rely heavily on consistency. If stories shift, trust erodes fast. Let me ask you, do you think someone struggling with addiction deserves more chances? Or does repeated testing failure show they're not taking court supervision seriously? Because from here forward, every answer she gives will determine whether the judge sees a struggling person trying to recover or someone trying to dodge responsibility.
And then finally, it almost appears wasn't masked enough and the cocaine gets picked up.
Understood, Your Honor. We've been doing this for enough time to know that. I just want to let you know.
You have been doing it, or are you saying me?
You, Your Honor.
Oh,
I know.
so now you're calling me old. Go for it.
Oh,
Keep going. You're doing well.
didn't mean to do that. Your Honor, I just would ask this court any leniency possible. I know you know our situation.
I do, but the problem is that then come here today saying all of that, but that's not what she told community correction.
Well, Your Honor,
She denied use to community correction.
Your Honor, she's stating that she did not deny use. Okay, there's a positive test. That's what we're here.
Hold on a second. You want me to get community corrections over here?
Would that help?
Not you, I don't think. She's denying use to community correction. You have the report in front of you, counsel?
Yes, I do.
Look at the box.
Yes, I
What's
see
it
it.
say?
It says denies use. That was,
She's saying that didn't happen.
yes.
So she admitted use.
Now she's admitting use.
No.
This is where things start unraveling, and courtroom viewers instantly recognize the danger. The judge now has paperwork directly contradicting what's being said in court. And when official reports conflict with a defendant's statements, judges immediately question honesty. Notice how confusion grows in real time. The defendant claims she didn't know what substances were being referenced, suggesting misunderstanding rather than denial. But from the court's perspective, that distinction matters less than the appearance of inconsistency. Courtrooms run on records, not intentions. If paperwork says denied use, that becomes the official version unless clearly corrected. And judges tend to side with documentation over verbal explanations. This is also a reminder. Communication with probation or community corrections officers must be crystal clear. Misunderstandings can look like deception. What do you think? Was this genuine confusion or an attempt to avoid admitting drug use until proof appeared? Because now, the judge is about to move from questioning into decision mode, and patience is running thin.
But she's talking to community corrections. What did she tell community corrections?
Can I speak?
You can do it. Hey, it's
So
up
when
to
the lady,
you.
so before Agent Carr called, the lady called and said it was illicit drugs. I told her I didn't know what illicit, I said, what is illicit drugs? And she said, I can't tell you the exact what it is. Call your agent. And when I called Agent Carr and she said what it was, I told her, okay. So I never denied it, but the lady that called from the lab called and just said illicit drugs. And I didn't know what illicit drug was. So that's probably what I came in contact, but I mean, you could ask Agent Carr. I definitely didn't deny use. Once I talked to her.
So then how did the cocaine get in your system?
What you mean? How did it get in my system?
Yeah.
Okay.
When?
When? I like, I don't know, a couple of days before.
Anything else?
In the abnormal creatinine, I mean, that pops up. I have kidney problems. So that I got a report on that. She wanted. So, I mean, that been in a lot of my tests and all the stuff still pops up. It's literally in almost every test that I had, but things still popping up from stuff that I'm prescribed and the cocaine.
Anything else? What are we doing with this? Case.
Well, Your Honor, I spoke with Mr. Ganatra. He was kind enough to honor the offer made the last PCC. I was just trying to ask this court if it had any leniency for this situation.
To do what?
Excuse me?
What were you asking me to do?
Your Honor, I'm asking for any leniency for this bond violation.
Okay, so on March 14th, she was here. I told her no more missed test, right?
Yes, you did.
I also gave her an admonishment about how she was treating the people. I'm trying to think at what date I had to do that. Back in December, she was mistreating the people over at Community Correction.
That'd be the 11th.
In December.
Yeah. December 11th, bond violation.
And then don't make it a few months. And then I have to tell her, don't miss test. And then she tests positive.
Your Honor,
She just seems to do what she wants to do herself.
you wanted me to let you know that she's struggling. And she has a special needs child at home and going through a lot. So
The cocaine helped.
And there it is, the sentence every defense attorney fears hearing from a judge. When a judge concludes a defendant ignores court instructions, it signals that leniency is disappearing. Look at the timeline the judge lays out. Missed tests, attitude issues, warnings, more chances, and now a positive drug test. Judges don't usually explode emotionally. Instead, they document patterns calmly, which actually makes the criticism more serious. The defense tries shifting focus to personal hardship. A special needs child, stress, struggles at home. And those realities matter. Judges are human too. But here's the legal reality. Hardship does not excuse violating court conditions. This is the crossroads moment. Does the court continue offering help or decide accountability must come first? Let me ask you, if someone is struggling but keeps breaking rules, should courts prioritize punishment or rehabilitation? Because what happens next depends entirely on whether the judge still believes change is possible.
no, obviously not. Look where we're at.
What were you gonna do with the case itself? No.
Yeah. Oh, go ahead, Mr. Ganesh.
So there's a plea offer, but I've not written up the plea form while she's got.
Yeah, that's not gonna happen today. How often are you using? Now, young lady, you can, as your counsel has indicated, I guess I'm old and I've been doing this a minute. So you can go ahead and tell me what you want to tell.
I mean, I don't want to tell you anything but the truth. I take responsibility for it. And
How often are you using?
like you want to is it an everyday thing?
I don't know that that's a hard question.
I have a problem with it. I stopped it and I started back.
Was that my question?
But a couple times.
Okay, look, no. Here's the thing. I don't mind trying to find a way, pretty much everybody in this room that's involved in the system, try to have you work this out and try to assist you to try to get past something. But if you don't want to answer my questions, you want to skate around everything, I don't have time for it. So here's what I'm going to do.
Probably a couple of times a month.
Well, now you want to answer me, right? I'm going to adjourn the probable cause conference. I'm going to adjourn it out 1 week to the 18th, 2024 at 9 a.m. This time, given the violation, you can think about what you really want to say. Defendant's bonds revoked, defendants remain.
And just like that, freedom disappears. Bond revocation is serious. It means the court no longer trusts the defendant to remain compliant outside custody. What's interesting here is the judge doesn't completely shut the door. Instead, he schedules another conference almost as if saying, "You still have a chance, but you'd better get honest." Judges sometimes use custody as a wake-up call. Time in jail forces reflection, removes distractions, and pressures defendants to confront their situation. But here's the risk. Once someone is in custody, their life outside starts collapsing. Jobs, childcare, housing, everything becomes unstable. So, bond revocation affects far more than just freedom. Do you think short jail stays actually help people change, or do they just make already difficult lives harder? Because the next time we see this defendant, the entire tone of the case will have shifted.
Court calls case People versus Desir Exton.
And Matthew Mansour, Assistant Public Defender, with and on behalf of Exton. Here's my right. Exton, can you state your name for the record, please?
Deja Exton.
I have before me a plea form that indicates that the defendant would be pleading guilty to added counts 3 and 4. 3 being attempted possession of a loaded firearm in a motor vehicle, the 1-year offense. And count 4 being use of a controlled substance, also the 1-year offense, also a 1-year offense. On her successful plea to those charges, counts 1 and 2 would be dismissed. That's the court's entire understanding of the agreement.
That's correct, Your Honor.
That's correct, Your Honor.
May I have her sworn?
Raise your right hand. You solemnly swear and affirm the testimony you're about to give the truth, nothing but the truth, so help you God.
Yes.
State your name.
Deja Exton.
Ma'am, it is this court's understanding that you're going to be pleading guilty to 2 misdemeanor charges. Is that correct? First is the charge and added count 3 of attempted possession of a loaded firearm in a motor vehicle. That's a misdemeanor punishable by up to 1 year incarceration, a $1,250 fine plus court costs, and mandatory forfeiture of the weapon. You understand that?
Yes.
Count 4 is use of a controlled substance. That is also a misdemeanor punishable by up to 1 year incarceration and or $2,000 fine plus court costs. Do you understand that?
Yes.
Now we move into plea territory, and this part matters legally. The defendant is pleading guilty to 2 misdemeanor charges, while more serious counts are dismissed. That's a negotiated outcome, and honestly, likely a strategic win compared to risking trial. Possessing a loaded firearm improperly and drug use charges may sound minor, but both carry up to a year in jail. Combined, they expose her to serious consequences. Notice how carefully the judge explains rights being waived. Trial rights, appeal rights, everything. This is to ensure the plea is voluntary and informed, so it can't easily be challenged later. This also shows the system trying to balance accountability with resolution. Trials are costly and uncertain. Plea agreements resolve cases efficiently. Question for you: would you take a plea deal to reduce risk? Or fight charges at trial even if the penalty could be worse? Because now attention shifts from guilt to sentencing and whether she'll stay free until then.
You also understand, ma'am, while I'm taking your plea, I would not be your sentencing judge. You would be sentenced before Judge Freshour in the 14A4 District Court.
Yes.
Still wish to plead guilty
Yes.
to the charge of attempted possession of a loaded firearm in a motor vehicle? How do you plead?
Guilty.
To the charge of use of a controlled substance? How do you plead?
Guilty.
And you understand that by pleading guilty, you will not have a trial of any kind.
Yes.
You signed an advice of rights form today, is that correct?
Yes.
Any questions regarding any of those rights? Please look at paragraph 5 on that form. Those are your rights which are part of a trial. By pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead to this charge?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily
Yeah.
of your own free will
Yes.
because you believe that you are indeed guilty of these offenses?
Yes.
On May 22nd, 2023, at the location of Tower near Ann Arbor. Yes, okay. In the city of Saline, Washington County, state of Michigan. Were you in a motor vehicle?
Yes.
Did you have a weapon in that vehicle?
Yes.
What was it? Was it a pistol?
Yes.
Where was it located?
Under the seat. I mean, in the Kia Soto.
I'm sorry?
In the car, in the Kia Soto.
Got it. You don't have authority to carry a weapon in that fashion. It was in the passenger compartment, correct?
Yes.
You don't have permission to carry it in that fashion that you were carrying it, do you?
No.
All right. Did you also have in your possession heroin and or fentanyl?
Yes.
Had you used it?
Have I used it? Yes.
Had you used it? Okay, and you knew what you were using was heroin and or fentanyl?
Yes.
Counsel, have I complied with the court rule? Would it be proper to accept this defendant's plea?
People are satisfied.
Defense is satisfied, Your Honor.
Court will accept the defendant's plea of guilty. 2 counts 3 and 4, counts 1 and 2 are dismissed. Pre-sentence investigation and report is ordered at 14A4. Probation. Sentencing in this matter will be
April 23rd at 9 a.m. before Judge Freshour.
April 23rd, 2024, 9 a.m. before Judge Freshour.
Your Honor, my client would like me to address bond.
Go ahead briefly.
Thank you, Your Honor. Ms. Exton is Michigan born and raised. She's a Detroit resident. She's a full-time mother with full-time custody of a 3-year-old daughter. She works full-time at Amazon at the Brownstown location. She's not sure if she still has that job, but she's been employed there ever since November. To my knowledge, she has no open criminal cases. She's not on probation. She's not on parole. Her iChat is clean. Her record of appearances in this court, she's never missed a date. She does not own or possess any firearms. She has no plans to leave the state of Michigan anytime soon. We know she has not been perfect while testing on bond. She has spent the entire week in jail. She had a lot of time to think and reflect on her mistakes. All this time away from her child. Her 80-year-old grandmother is struggling right now, trying to help take care of that child. Your Honor, I'm asking for a PR bond on her behalf, allowing her one final chance to show you that she has learned from her mistakes, and she personally would like to apologize to you herself.
Defense counsel now pivots to mitigation, presenting the defendant as a working mother, stable resident, and someone with family responsibilities. This is classic bond advocacy. Show the court she has reasons to stay compliant and appear for sentencing. Notice the emotional appeal: childcare struggles, employment risk, elderly family support. Judges consider these factors, but credibility remains the deciding factor. Also important, she's already spent a week in jail. Defense argues that time served already had corrective impact. Courts sometimes see short custody stays as enough punishment before sentencing, but the judge remembers everything: missed tests, attitude problems, dishonesty concerns. So here's the engagement question. Should courts give one final chance when children depend on the defendant at home? Because next, something powerful happens. Family members step in and the emotional temperature rises sharply.
I can speak. Oh,
If you'd
yeah.
like.
I apologize for the way my attitude been perceived in this court.
Perceived?
I mean, I apologize. That's not who I am. I had a lot of time to reflect on my actions, and I learned my lesson. I don't want to be that person.
Your Honor, can I speak?
I don't know who you are.
Oh, my God.
Yelling from the, who is that? Who are you?
I'm her mother.
Go ahead, man. I need your name.
My name is Heather Gregory, and you're right next to mother. I'm here because she do have a 3-year-old child that's a special needs child. I work all the time, over 60 hours. I just came back from out of town, and my mother is struggling to take care of her daughter by herself because we just lost my father if we gotta have on a tether or whatever, Your Honor, we definitely need her home. Because my mother cannot take care of the child and I work too much.
She explained to you what she did?
She did,
She did not?
she did not. She did not tell me.
Okay, let me just put it to you this way, Mom. She's in custody because she worked her way there. I mean, it wasn't just where I just threw her in. She was coming, she had issues over with an attitude problem over at community corrections and doing stuff there. I gave her a warning.
This is one of the most emotional courtroom moments. When family members step forward, reality hits differently. The judge explains clearly, custody wasn't arbitrary. It resulted from repeated choices. And judges often speak more plainly to family because they need them to understand consequences too. Family support can help defendants succeed or enable continued mistakes. Notice how the mother admits her daughter has an attitude problem but still begs for her release. That honesty actually helps because courts value accountability. This is where we see the ripple effect of criminal behavior. It's not just about the defendant. Children, grandparents, entire families feel the consequences. Let me ask you, should family hardship influence court decisions, or must consequences stay strictly personal? Because now the judge must decide whether another chance is deserved or wasted.
Didn't lock her up. She was supposed to be testing. She was supposed to be doing everything. Next thing I know, she shows back up here. And she not only has abnormal creatinine levels, which would be positives at any event, I was still giving her the benefit of the doubt, but then shows up with cocaine in her system. That's how she ended up locked up. So the difficulties are not because of anything the court's doing, it's because of what she's not doing and then not telling me the truth.
I mean, like I said, I didn't know the food was finished, I didn't have the time, I run out of time, you know, so I didn't know what happened, but she was court, I mean, we had locked her up. And like I said, she got a special needs kid, a daughter that had cerebral palsy, which my mother is trying to take care of. And it's hard, I know she's not perfect, and I know she has an attitude
Oh, yeah, she does.
problem, which I mean, she might have got it from me, but I definitely need her home because I got this grandchild that needs her. So over all that, Your Honor, I'm just asking, can you please give her another chance? If I gotta watch her, I will, but I definitely need her home for my granddaughter's sake.
Any response from the people?
No.
Thank you. Thank you, Mr. Gunnar. Outside of that, Mr. Why should I even bother letting you out? Because I just have a feeling what's going to end up happening is Judge Freshour is going to have to lock you right back up.
I'm not gonna be the person that I was. I had time to think in jail, trust me. I don't wanna be there.
Their previous month. Of course, messed everything up. Mhm. $5,000 personal recognizance bond. I'll reinstate previous conditions.
You need to thank him.
Thank you, Judge Simpson.
And against the odds, the judge gives her another chance. But listen carefully. This is freedom with strings attached. GPS monitoring, home confinement, drug testing conditions. The court is tightening supervision dramatically. This decision shows something important. Judges sometimes choose structured supervision over jail, hoping accountability works better outside custody. But the warning is clear. One mistake, and she goes straight back to jail, possibly until sentencing. This is the last lifeline moment. The judge's patience is nearly exhausted, but he still leaves a narrow path forward. So here's the question. If you were in her position, would this be your wake-up call? Because the next step, sentencing, will decide whether this story ends with redemption or regret.
Thank you,
You
Your
what?
She would get a different date.
Yeah. Difference. But hold on, a moment. Reinstate the previous conditions. Also indicate that there's to be no further tests. I will also order a GPS tether. Home confinement, except work.
Your Honor, could I get that date one more time if it changed? For
She
sentencing?
didn't give it to you yet.
I'm sorry.
Sentencing date now will be one, May 14th, 2024, 9 a.m. before Judge Freshour. Be sending a note to Judge Freshour, so young lady, if you mess up one bit, trust me, you'll be right back. Understood?
Yeah.
Thank you.
Thank you, Your Honor.
Let's wrap this case up professionally. The defendant ultimately pleaded guilty to misdemeanor firearm possession and drug use charges, with more serious counts dismissed under a plea agreement. However, her bond violations, drug test failures, and courtroom credibility struggles nearly cost her freedom before sentencing. Judge Simpson's rulings highlight a broader reality of the justice system. Courts constantly balance punishment, rehabilitation, and public safety. Here, the judge chose strict supervision instead of continued custody, giving the defendant one final opportunity to stabilize her life before sentencing. But the outcome still hangs in the balance. Sentencing will depend heavily on whether she complies moving forward. One violation could erase all progress. This case also reminds us how addiction, personal struggles, and legal consequences intersect, affecting not just defendants but families and children as well. Now we want to hear from you. Was the judge fair, too lenient, or exactly right? And if you found this case as shocking as we did, make sure to hit that like button. Share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.